Hello everyone. In this video I'm going to explain about the hierarchy of courts in England and Wales and a little bit about the judiciary. So depending how long the video goes on, at the end you will be able to tell apart civil law from criminal law. You will realise what the burden of proof is, what standard of proof is offered in both systems. You will know what the structure of the principal and civil criminal courts is and what their different areas of jurisdiction are. You shall also hopefully understand what precedent is about in courts and how this applies to hierarchy. You should understand what appeals are about and have some idea about the system of appeals in civil courts as well as in criminal courts, and also understand the significance of the Supreme Court, which was set up about 15 years ago, and some of the changes which have followed in its train, as well as being aware of some of the ideas people have forwarded about amending the court structure. So by civil law, in this case, we mean non-criminal law. Confusingly, civil law sometimes means Roman law, such as you find in Francophone countries, Hispanophone countries, Lusophone countries, and so forth. The role and the jurisdiction of courts in Wales and indeed in England makes a distinction between criminal matters and civil matters. So there are two parallel structures dealing with either civil and criminal, but they meet at the Court of Appeal, and obviously they're still fused in the Supreme Court. There's a little bit of overlap between the twain, which is a trifle confusing. So civil law is part of private law, that is to say an individual against another, or indeed a private organization, a company against an individual, two companies against each other. So the state is not one of the parties. It can be between legal persons, which could be an organization, a company, a charity, a church, a school, something like that, or as opposed to a natural person, i.e. moi. Any humanoid is a natural person, but not a legal person, because organizations have a legal personality. So civil law takes in contract, tort, company law, the law of property, and so forth. Tort meaning wrong in French, like tort. If you did wrong to me, you're a tortfeasor. It's tortious malfeasance. So in civil cases, the state is not a party and is not concerned about the result. So it's up to an individual to assert his or her rights. The state's not going to do it for you. In a civil case, the person who brings the action is called the claimant. In the old days, we say plaintiff, as he or she was plaintive. I have a feeling in the United States they still say that. They're plaintiff, they were sad because they've been wronged, so they claimed. The person against whom the claim is brought is known as the defendant. So the claimant is said to sue the defendant, as in to pursue, to chase them through the courts, and they're seeking a remedy. Put it right, give me what I should have had, pay me compensation, stop saying that, whatever could it be. So the judge eventually gives his or her judgment for the claimant or defendant. So in these civil cases, the actions are named after the parties, and the first named is the claimant. Carlyle and Carbolic Smokeball, 1893, a very celebrated contract case. Mrs. Carlyle was the claimant, whereas the defendant was the company, Carbolic Smokeball. And so we often say it like that. So likewise in criminal law, the one who moves the action is the Crown, as named first. So then sometimes if somebody appeals and the person appealing is called the appellant, or the party appealing is called the appellant. Party can be one person, could be an organization. So we say the party. The person opposing an appeal would be called the respondent. We even used to have co-respondent in divorce cases, as in say, he committed adultery with her, so I'm allowed to divorce her. So someone who loses a case, the respondent, if the respondent loses, sometimes they win, could then appeal themselves, in which case he becomes the appellant. Confusing, I know. And the other side, if they're opposing this appeal, would be the respondent. All right, so let's have a look at criminal law. Now, this is an area of public law. Other parts of public law are administrative law, human rights law, constitutional law, immigration law, and social welfare law, because the state is a party to it. So it's about the relationship between the state and the individual, or sometimes between private organizations and the state. So the state is active here because it usually is the one who moves the action, saying, "Oh, you're claiming benefits you shouldn't be. You killed her," or "you'll have to be deported," something like that. So there is a prosecution which represents the Crown, arguing the person is guilty, and the prosecution prosecutes the person who is accused of a crime. He's the defendant. Sometimes we call the defendant the accused. And the state is seeking to get a guilty verdict and then to get the person penalized, possibly through incarceration, paying a fine, some sort of restraint on what he or she can do. Anyway, so at the end, the jury, or sometimes just a judge on his own, delivers a verdict which announces the person's guilty or not guilty. Now, not guilty means in effect innocent. We don't know they're innocent, but obviously it hasn't actually been proven that the person is guilty, when we simply assume the person is innocent as a lamb. So the prosecutions are almost invariably brought by the Crown. There are private prosecutions, vanishingly rare. You can initiate those. Though the Crown Prosecution Service has the right to issue an order of nolle prosequi, that's Latin for do not prosecute, and to terminate this action. So usually it's R and white. Okay, R standing for Regina, as in Queen in Latin, or the old days Rex. But we sometimes say the Crown to mean instead of R. And if it was R and white, white is the person being prosecuted. And we often have a year at the end of the name of a case. That's the year of decision. If the case began in the year 2000, finished in the year 2001, then the year of the case will be 2001, because that's the year the case was decided. Anyway, so you have to make sure you understand the nomenclature and use it accurately. So don't talk about someone in a civil case who was a defendant, say that the person was guilty, because they're not guilty. They lost the case. And there's no punishment awarded in a civil case, but there is a remedy awarded, which might be one party paying compensation to another, actually doing something, specific performance, for instance, in the case of contract law. Or you have to perform the contract. You have to do what you agreed to do. Or you have to restitution of goods, something like that. Cease and desist. Okay, so which action should be brought? So the thing is, the same case could cause criminal proceedings or civil proceedings. For instance, supposing somebody gets blind drunk and knocks down someone who's walking along the street. Someone's driving, that is. And anyway, the person suffers injuries, the victim. So there's a criminal case because drink driving is a crime. So the Crown could prosecute this person for driving above the legal limit of alcohol in his system. But there's also a civil case here because the person might... The victim might say, well, I'm going to be a claimant and this is actionable, as I can take legal action in the civil sphere against the person and win compensation for the injuries that I've suffered. So this is an action under tort, as in wrong, T-O-R-T. When I first heard tort, I thought, what, taught, as in past tense of teach? No, tort. But if you're of a non-rhotic accent, the R doesn't come out. Okay, so if a tort is also known as a civil wrong, it's not a criminal wrong. A crime, we often say criminal offence, as a just offence, all the same thing. We're very PC. We don't want to be too blunt with our precious little criminals. We don't want to hurt their feelings by saying it's a crime, or even call them criminals, we call them offenders. Just like the police is not a force, we don't want to use force, police service. There's a thing called judicial review, and this is a part of public law again. There are complex core philosophical ideas about this and processes which aren't exactly civil law or criminal law, but they're about ensuring that public bodies act lawfully, like Parliament or even the courts themselves or county councils or, oh my goodness, I can't think, young offenders institutes, orphanages, prisons, the NHS, the army, and so they're called like this. They have R and then the brackets, the person on whose behalf that they are moved. So R, as in Regina, the Crown, and brackets could be Chief Constable of the West Midlands Police, for instance. And then who it's against could be Salford NHS Trust or something like that. But sometimes you see judicial reviews cases cited differently. Factor tame is a very common one. For some cases so well known, just known by a single word. For instance, R and Secretary of State for Transport ex parte factor tame limited number 2, 1991. So that was the Crown, but the Secretary of State of Transport was doing it on the behalf of factor tame limited. That's why I say ex parte. Factor Tame Limited. That was a Spanish fishing vessel. Okay. So now we come on to looking at proof. So one party has to prove his or her case. We often call this the burden of proof. So usually, in a civil case, the claimant must prove his or her case. Obviously, in a criminal case, the Crown must prove the case. But in some instances, the burden of proof is the opposite way around. For instance, in libel, that's if you lie about somebody to damage a person's reputation, the defendant has to prove what he or she said is true. I think I'll talk about that in tort in more depth. Defamation, one of the juiciest areas of law. Okay, so on a charge of murder, a defendant could say, yes, I did kill the person, but there was diminished responsibility. I wasn't fully accountable for what I did because of I was somehow mentally ill at the time, or I'd been in an abusive marriage, been beaten up for years and years, or there was a qualifying trigger. The person said something so grossly and hideously offensive to me, I just lost it with that person, and a reasonable man would have reacted in a like manner. So there's a standard of proof. So how much is proof? Do we need absolute certainty? You virtually never achieve that. But in civil law, it's the balance of probabilities. What's more likely? More like over 50%. Whereas in the criminal law, it's very different, which is to say, beyond all reasonable doubt. You might have just a penumbra of doubt. So it's much more difficult to meet that standard, the criminal standard, than it is the civil standard. And that's why we have an option of going either way. People sometimes go for the civil case. If someone feels they've been terribly mistreated by the police, very unlikely to get to secure a prosecution here, to secure a conviction. So I tell you what, we'll sue them. We'll go to civil law. And so it was on the balance of probabilities. Did they mistreat you? Yeah, they did. Okay, so you got some compensation. So let's look at the courts a little bit. This is run by Her Majesty's Courts and Tribunal Service. Her Majesty so often abbreviated to HM. Now, so from top to bottom, in the senior courts, there's obviously the Supreme Court, but prior to 2009, it was the House of Lords. Now, there was an Act of 2005, the Constitutional Reform Act, to set it up, but didn't actually come into being to the 1st of October 2009. There's a Court of Appeal, which handles both civil and criminal matters. In fact, so does the Supreme Court, handles both civil and criminal matters. There's the High Court, the Crown Court. These are all called senior courts. Coming to the inferior courts, the lower ones, we got the small claims courts. People say, really, that's a procedure, not actually a court, despite the name, handling disputes of under £5,000. An ordinary person represents himself. If you're an adult, sound mind, then you can do it. You don't have to be a genius, don't have to have any law degree. As long as you're average intelligence, you can do it. People of very limited intelligence, very low literacy, are advised not to do it. You can get a lawyer to represent you there. It's usually not worth it because the money is so petty. The fees would eat away most of what you'd get. There's the county court, which is for civil matters, magistrates' courts, which is the lowest, criminal court, youth courts, as in people who are under 18 dealing with criminal matters. So bear in mind that civil and criminal courts, they sometimes fuse. We often talk about courts of first instance. You have to start in the court of first instance and then move up, because courts go up in tiers, as in levels. There are also appellate courts, which hear appeals from an appellant. So you think there's a wrong decision, you can appeal, go to an appellate court. They might reverse a decision of the lower court. They might not. They usually uphold it. You fail in that appeal, sometimes you can appeal even higher. Obviously, the House of Lords, the Supreme Court's the top. There is a court of cassation. You cannot appeal beyond the House of Lords. So you notice it's very important that there is a hierarchy to this structure. Okay, so let's look at the civil courts. The Supreme Court. So the Supreme Court is supreme in terms of its appellate jurisdiction. You can't appeal beyond that. It was previously called the House of Lords, and it indeed met in the House of Lords. Now it meets just across the street in a building on Parliament Square. So it was set up in 2005, but as I say, planned in 2005 with that piece of legislation, but didn't actually begin to act until 2009. Anyway, so the House of Lords had that jurisdiction after the Appellate Jurisdiction Act of 1876 to 78. So why was this separate court set up? Because, the Labour government under Blair felt it was vital to distinguish between Parliament and the courts. They shouldn't be merged. They felt that was deeply wrong, separation of powers and all that. So it's the old building of Middlesex Guildhall that they run. London County Council used to be run there from 1889 till 1922, when London acted as a county, councillors meeting to decide local government matters for London. So it's part of the separation of powers. So let's look at who's in it and how it works. So the Supreme Court has 12 judges. One of them is a president, another is a deputy president. Lady Hale of Richmond was the president. She's just retired. The deputy president was Lord Reed. Well, he's now the president. I can't remember who the deputy president is right now. So they have to retire in their 70s. So a case is usually heard by 5 judges. We sometimes call them justices. And that's called a constitution, as in a group of judges. Which 5 of the 12 are you going to get? Well, that's a bit of a luck of the draw. Occasionally, they may choose to have a constitution, as in a bench of judges of 7 or even 9, if it's a really crucial case. For example, A and Secretary of State for the Home Department, 2004. And that was heard by 9, or R brackets Miller and Secretary of State for exiting the European Union in 2017, when Gina Miller, that Euro fanatic activist, said no, this is illegal. So 11 judges sat on that one. That's unprecedented. It is a measure of just the importance they attach with it. Notice it's always an odd number: 5, 7, 9, 11. Anyway, so the court listens to appeals about points of law if it's of national importance. For the United Kingdom in civil cases, for England, Wales, and indeed Northern Ireland in criminal cases, but not Scotland in criminal cases. So precedent, that's vital. So the decisions of the House of Lords are binding on all the courts beneath it. So the House of Lords used to be bound by decisions made by previous constitutions of the House of Lords, as in previous compositions of judges. See the London Tramways Company and London County Council 1898. Now in 1966, the Lord Chancellor, as in the judge who was head of the judicial system, Lord Gardiner, said something in the House of Lords on behalf of the Appellate Committee. And this is called the Practice Statement, Judgment, Judicial Decision as Authority, House of Lords. So the Appellate Committee suggested that from then on, it ought to treat its own rulings as usually binding, but it might break with previous decisions if he thought it was the right thing to do. So by saying that the doctrine of precedence is an indispensable foundation, they felt it had ossified over much, and sometimes injustice was done on that basis. So they're going to have to move on a bit. So in breaking with this previous doctrine of precedent, the Appellate Committee had to be conscious that it could possibly mess up some financial arrangements and property rights. And the thing is, in another thing they took into account is in criminal law, we need to be sure what the law is, so people don't unwittingly transgress the law. Okay, so that was considered a very bold step and disapproved of by some, much tut-tutting in the Inns of Courts as people quaffed their gin. So the House of Lords is a fairly small c conservative organisation because law is traditional. We need to have some continuity. We need to have clarity here. So another prime example of the House of Lords breaking with precedent is Anderton and Ryan in 1985, or indeed R and Shivpuri. So Anderton and Ryan, the House of Lords was contemplating the Criminal Attempts Act 1981, because could the defendant be innocent or not guilty, as we say, of attempting a crime, if it was impossible in that situation for a crime to have actually been committed. Because remember, attempting a crime, even if you don't succeed in completing the crime, is still a crime. So the House of Lords said there was no crime because it was impossible to carry out the crime in this situation, even though he tried his damnedest. So the decision was excoriated by many, and the House of Lords decided to break with this ruling the next year in R and Shivpuri. So the defendant was guilty of an attempted crime, even if it was impossible to actually carry out the crime. Supposing you plotted to murder someone, the person then died naturally, and then you went ahead with your murder plot, only to discover, oh, well, he's dead. You'd be guilty of a crime. It was impossible to actually carry out the crime on that day because the person already died, only you didn't know it, but you were still guilty of attempted murder, for instance. That's not the particular examples from Shivpuri. So in Austin and Mayor and Burgesses of the London Borough of Southwark, there's a case in 2010, Lord Hope said the Supreme Court didn't think that they needed to issue the practice statement again in the Supreme Court's name, that was still valid. Okay, so let's have a look at the Court of Appeal in the Civil Division. What's its makeup and what's its purpose? Well, that was set up by the Judicature Act of 1873, and it's got two divisions, civil and criminal. The split came in 1966 into civil and criminal. So it hears appeals from civil cases in all three sections of the High Court, or divisions as we call them. And it also is a place where people go to appeal from various tribunals, including the Employment Appeal Tribunal. So the person who's in charge of the Civil Division is the title of Master of the Rolls. At the moment it's Sir Terence Etherton. There are Lord and Lady Justices of Appeal, and they are moved up there from being High Court judges. So you've learned a lot about the different judges. I hope I'm not going too fast for anyone. Kind of going too fast for myself sometimes. Anyway, so usually 3 justices are on the bench when a case is being heard. The Master of Rolls is assisted by 2 others. So sometimes you have a full court, which is 5 judges, very rare. If it's something really vital, he'll have all 3. So there's only a majority decision. They don't require unanimity, and the dissenting judgment is also published, because the 3 of them might agree, 2 disagree, and we'll hear it'll be published what the 2 said in disagreement. We might also learn from that, and it could be in later decades the court changes its mind and says actually the dissenting judgment was correct. So we'll look at precedent, and again, the Court of Appeal, its rulings are binding upon all the courts below it in this hierarchy. So the Court of Appeal, of course, is itself bound by the Supreme Court, or previously the House of Lords as it was. Incidentally, when the House of Lords was the highest court in England or Wales, or indeed the United Kingdom, it was only the judges in the House of Lords. It wasn't the doddering hereditary inbreds. Okay, so there are certain exceptions. For instance, in Young and Bristol Aeroplane Company Limited, 1944, if there are 2 previous rulings of the the Court of Appeal which clash, the court is going to pick between them, because you can't follow both. It doesn't have to follow its previous decision when that decision has been expressly or impliedly thrown out by the House of Lords. So impliedly, not saying it outright, but we can deduce from that, we can read between the lines. The implication is that ruling is invalid, it's chucked. Now, the Court of Appeal can choose not to follow one of its own previous decisions if it was given per incuriam. What does per incuriam mean? It means without care, if you know your Latin. So this comes about where a pertinent statutory provision or precedent which might have changed that decision was not drawn to the court's attention in that previous case. And so the oversight needs to be serious enough that it would have materially changed the legal reasoning in the case. So this principle is used not very often. You've got to be careful about this one, but we don't want to go around wildly ripping up precedent, because then we don't know where we are. So it doesn't apply if the earlier case was not properly argued. It can appear to take the wrong view of authorities, or to have misunderstood a statute. These things are very lengthy and complex, and they're like gaps left in them. I know they are learned in the law, but it's possible to err in law, and that's a valid legal argument that somebody erred in law. I remember one of my barrister friends saying there's some sort of murder case, but the jury weren't told that they didn't have to convict of murder; they could convict of manslaughter, and they convicted of murder. So that was a problem, and that's why there was an appeal on that case, which was successful. All right, so the precedent can be disregarded if the court made a ruling per incuriam, but it's very limited, the usage of this. So the Court of Appeal usually tugs the forelock to its previous decisions, and likewise to those of the House of Lords or the Supreme Court, which of course superseded the House of Lords. And some people have objected to this down the centuries. For example, look at Castle & Co. Limited and Broome, a case from 1972. And Lord Denning, who was then Master of the Rolls in the Court of Appeal, he wanted to avoid the decision which was made by the House of Lords in Rooks and Barnard, 1964. It was a decision on exemplary damages, as in very high compensation you had to pay as a warning, don't do likewise to others. So that went up to the House of Lords. So Lord Hailsham, Conservative peer, bit politically active in a way would be considered deeply inappropriate these days. So it's not open to the Court of Appeal to give gratuitous rights to judges of first instance and ignore the decision of a House of Lords in this way. So some disagreement between the top law lords. So bear in mind that the efforts made by Lord Denning to say that after 1966, the practice statement that because of the Court of Appeal no longer had to follow its own decisions. It was no longer bound by its own precedent. So many people in the House of Lords thought that Lord Denning was dead wrong on this. See Davis and Johnson, 1978. So Lord Denning was a very, very famous judge who only died in 1998. He was almost 100 years old. A chap from Hampshire with a distinct West Country burr. Had quite a curious life story. He won even the respect of Tony Blair. He come from a humble family, got one in place itself, a place at Oxford, had to sort of teach himself Greek from scratch. By the age of 18, had to get up to the same standard in ancient Greek as boys from posh schools had been learning it since they were knee-high, and he succeeded. A mathematician, a master at Winchester College, who later was called to the bar. So an unusual background for one who rose to so high, to wear that full-bottomed wig. Anyway, onto the High Court and its composition and how does it work, what's it for. Right, so the High Court at the moment is part of the Supreme Court of Judicature, and it was set up by the Judicature Act of 1873. And so the judges there, they mostly hear cases in London, but they could hear cases at any place in England or Wales, though it's rare for them to venture beyond London. So the Administration of Justice Act in 1970 reworked the court into three decisions. That's the Queen's Bench Division, the Chancery Division, and the Family Division. The High Court is now controlled by the Senior Courts Act of 1981. So where am I on my notes? Yes. This used to be called the Supreme Court Act 1981. The Supreme Court and Legal Services Act 1990, they also govern this court as a Civil Procedure Act of 1997 and the Civil Procedure Rules of 1998. So from 2018, the presidents of each of these courts, that's the most senior judge in each court, the Queen's Bench Division, the Family Division, and the High Court over the Chancery Division, are all men. People say, oh, that's wrong, we've got to have more women. And they're knighted, they're Sir whoever, Sir Geoffrey, Sir Brian, and Sir Andrew. So the High Courts are sometimes called puisne judges. It's spelled Puisne, but pronounced puny, as in small, rather demeaning. So a puisne judge is appointed by Her Britannic Majesty on the advice of the Lord Chancellor. The Lord Chancellor is a political figure in the House of Commons, despite their title Lord Chancellor. It was Michael Gove last time I checked, who goes round with this long black gown with braided in gold, which I'm sure does a lot for his ego, a bit like the Chancellor of a university does. So he's a politician. He's no longer a judge like he used to be. So he's these days called Chancellor and Secretary of State for Justice. That Secretary of State for Justice thing is a fairly new thing. Okay, so what's it all about? So the High Court is here very important cases, civil cases. At first instance, they can start there if they're important enough. It has unlimited jurisdiction compared to other lower courts, which are only allowed to hear a case up to a certain amount. Depends how much money is involved. So it's the only one which has jurisdiction over some cases, for instance, defamation, as in lying about somebody in a way that damages his or her reputation. And there are other categories. The jurisdiction is sometimes shared with county courts, for example. There is never a jury in a high court except sometimes in defamation or false imprisonment, as in locking somebody in a room without the person say so. Occasionally malicious prosecution cases. You prosecuted me when there was no reasonable grounds for doing so. Not only was I innocent, there was no reason to seriously suspect I was guilty. Or sometimes in fraud cases. So it might seem odd. Why are these not criminal? All right. So what do? The Queen's Bench Division, often abbreviated to QBD. This deals with common law cases, particularly contract and tort, and it's the biggest division and it's kept very busy. It's got commercial sections, admiralty sections, admiralty to do with shipping, and there's a technology and construction court known as the Official Referees Court, because this is about building things, and there's like engineering law, and if it collapses, it's structurally unsound, so very technical. The barristers in that section, they often have a degree in engineering, chemistry, physics, something like that. Because you have to not only know the law, you have to understand the science and the maths behind it. Then look at the look at the family division. That's mathematical. It's to do with wardship, adoption, divorce, and then related matters such as custody of children, legitimacy. It might seem an ugly word these days. Is somebody born in wedlock or not? It may seem very unfair, but that still affects inheritance rights. Okay, let's look at the Chancery Division. This deals with company matters, partnership law, trusts, law of property. We often call it land, mortgages, bankruptcy, intellectual property is part of property as well. And that's smaller than the Queen's Bench Division. So there are different companies, bankruptcy and patent courts. Within that, the judges have particular specialist knowledge of each field. And it's also about restrictive practices court. So it's an area of contract. If you're trying to stop somebody practicing his or her trade with too wide a geographical scope or too long a time scale. But I think I'll get into that in greater depth when I come on to contract. So each division within the High Court is known as a Divisional Court, and there are at least 2 judges. Sometimes there are more, and they have particular functions such as hearing appeals. So there's an administrative court, and that's part of the Queen's Bench Division. It used to be called the Queen's Bench Division Divisional Court. How confusing is that? Divisional. And it handles appeals. That these come up from the Magistrates' Court or indeed the Crown Court, sometimes when someone applies for writ of habeas corpus or they apply for judicial review. Habeas corpus, do you have a body? Literally. Okay, there's the Family Divisional Court, and that is on family matters, for appeals on family matters. And lastly, there's a Chancery Divisional Court, and that listens to appeals from the County Court on some issues such as bankruptcy, appeals from the Inland Revenue Commissioner, he's the nasty bloke trying to tax you, and things like that. All right, I think that's enough for the moment. We shouldn't do much over half an hour. See you next time. Toodaloo.